considered this simple yet powerful truth. In the digital landscape, digital evidence is a silent witness that either cements justice or shatters a case completely. Today's topic of discussion perfectly captures this reality. Digital evidence decoded. What makes or breaks a cybercrime case? I am Yashwant Vemana Reddy, and it's my privilege to anchor today's session. This lecture is part of our Cyber Sunday series, an initiative designed to promote awareness, learning, and informed engagement in the field of cyber safety, law, and technology. Through Cyber Sundays, we bring together experts and practitioners to share real world insights into cyber threats, governance, and investigation strategies. If you are ready to start this journey, type ready or show your enthusiasm through a thumbs up emoji in the chat. It's a great privilege and honor to welcome our esteemed guest speaker for the 23rd Cyber Sunday, Advocate Akshay Bambi sir. Akshay sir is a distinguished cyber law practitioner, legal educator, and the founder of HAK Bhamri and Associates, South Delhi. An LLM gold medalist in cyber law and a prolific speaker with over 75 seminars, he is driving the force behind the Cyber Nose project and the author of the upcoming book, Cyber Shastras. We are incredibly honored to have him with us tonight to break down how digital evidence truly shapes a cybercrime case. Please join me in extending a warm and respectful welcome to Akshay sir. Without a further ado, I would like to hand over the mic to you, sir.
Good evening, everyone, and namaskar, everyone, to all the participants who have joined today. And welcome to the Cyber Sunday episode 23. I am Advocate Akshay Bhamri, the guest speaker for today, with the project Cyber Shield, discussing the theme Digital Evidence Decoded, What Makes or Breaks a Cyber Case. And I'm too grateful for the Cyber Shield project and Naksh Foundation for this wonderful initiative. I'm especially happy to speak with all of you today who have joined this session and want to discuss something related to the cyber case today. And digitally evidence will decode that will make or break your case today. Can I request the presentation to be on screen?
Yes, sir. Please wait a minute.
So before that, every participant, if there's any question regarding anything related to this theme today, you can just please drop in the chat box, or at the end of the session, I'll be taking your question and answer. We'll be discussing this cyber digital evidence in detail. I'll discuss the journey of the evidence, how an electronic evidence from and becomes a physical evidence when presented in court. This slide will be on your screen within the next few seconds. Before that, I'll just give you one of the most important discussion plan today that we'll be having. This session is a part of a Cyber Sunday series, and this aim to foster the awareness in cyber safety and prevention. Over the next few hours, we'll discuss and decode the digital evidence from its introduction and its emerging trends through a practical and a legal journey of electronic evidence. So I'll tell you, the most important thing in this topic is what makes your case or what breaks your case. That means where the cases succeed or where they fail, the court really expect the lawyer to decode the digital evidence in its primary form. We are not discussing the digital evidence today. We are discussing the most important aspect of an evidence. I'll tell you the most foremost line of today's lecture is, all of you sees digital evidence as an evidence, but what I see evidence. It's a weapon which can make a criminal walk free, or which can give a conviction to an innocent. So digital evidence is not just an evidence, it's a death and life matter for someone who is an accused in this case. I request the host, if you can present the presentation, it will be easier for us.
Sir,
Yes, sir.
actually,
Please, like,
we did not. one- Actually, we did not receive that PPT. Sir, you can, if possible, can you present it, sir?
Okay, just give me 2 minutes. Can you please once confirm with the coordinators? I have already shared the presentation. Please check once. To all the participants, the presentation will be on your screen in next 2 minutes. Just please bear with us.
Sir, just now I received the PPT. Sir, I will give me few minutes. I will just present it. And sir,
Okay,
please kindly, if possible, can you switch on your camera?
sure, right away.
Sir, can you mute yourself, please? Like, you are on unmute.
I believe to all the participants, just bear with me for some time. I'm just traveling. My network issues will be there. So I apologize for the same in advance.
Divya, I have presented the PPT. Just check it.
It's not on the screen once. Everybody, can you see the presentation? Yes.
Yes, sir, it's visible.
Perfect. So
Divya,
I just repeat once again what we have discussed. Namaskar to everyone who have joined this session. This is a Cyber Sunday episode 23. I am Advocate Akshay Bhamri, and the speaker for today. We'll be discussing this topic, digital evidence decoded, what makes or breaks your cybercrime case. So I'm grateful for the Cyber Shield and Naksh Foundation for this wonderful initiative, and I'm especially happy to speak with all of you participants that we are discussing one of the major topics of evidence. And this session is a part of a Cyber Sunday series. The only aimed and objective is to foster the awareness on cyber safety and prevention of the cyber crime cases in India. Over the next few hours, what we'll be discussing digital evidence from its introduction, emerging trends from where the digital evidence started, its practical and legal journeys of electronic evidence. One most important subject or line which I'll say, where your cases succeed or where your cases fails, the court wants the evidence to be relied on a digital evidence. So digital evidence, it's the most foundational and the foremost things that can make or break your case. You can please change the slide. So I'll tell you one most important thing about digital evidence. You see digital evidence as a part of evidence. What I see a digital evidence where an innocent can be behind the bars and the criminal can walk free. So do not see evidence, just a piece of evidence. Electronic evidence is a crucial thing which you, if you think this will succeed your case in each and every category. So just look at the table of content. We'll be discussing this in detail. Introduction, evidentiary pitfalls, what are the problems that evident value we face. Authenticity and admissibility, this is one of the most important thing. Evidence preservation, how to preserve an evidence, and what the authorities, especially like police, what are the problems they face. Forensic evidence, why it is important for a forensic in order to get the detail of the hash value of all the evidence, which we'll be discussing. Judicial trends, what are the judicial views pre and post. You can note down. We'll be discussing the digital evidence journey in 2 stages. Pre, that is pre 2000, and after 2002, there are 2 stages that we'll be discussing. Landmark case, there are a lot of landmark case on digital evidence that the Honorable Supreme Court, the Honorable various high courts have provide their solution to it, and how to handle what is the admissibility grounds and what we can do in order to preserve an evidence. The landmark cases and the conclusion. Just a note, I'll be taking a question answer at the last of the slide, or if you have any question answer related to the current slide, you can please drop it in the chat box. Please change the slide. So let us start with our first topic, which would be the introduction. Can you please change the slide, please? It's an introduction. Please confirm. Can you see the introduction slide on your screen?
Yes, sir. Yes, sir. It's introduction.
Perfect. So you can see this is the introduction slide. So we'll be discussing what a digital evidence is. First, understand what is an evidence, and then evidence can be in 2 forms. I'll tell you 2 things. Evidence can be in digital form. Evidence can be in physical form. So there are 2 ways that we can have an evidence we can present in a court. In this session, we'll not understand what digital evidence is. Likely understand it, we'll be addressing एक डिजिटल एविडेंस की एक जर्नी होती है. I'll tell you a journey from its source. कब वो पैदा हुआ डिजिटल एविडेंस, बीच में उसने what would be its career perspective and what was the ending of digital evidence. So आप इस डिजिटल एविडेंस की जर्नी को समझिए. मे बी आपको टॉपिक थोड़ा सा कॉम्प्लेक्स लग रहा हो. द टॉपिक इज नॉट मच कॉम्प्लेक्स, इट इज ईजियर. सो डिजिटल जर्नी की, डिजिटल एविडेंस की एक जर्नी होती है. अंडरस्टैंड द पर्सपेक्टिव एंड अंडरस्टैंड द स्टेजेस. जब आप एक जर्नी को समझने लगेंगे, देन यू अंडरस्टैंड कि डिजिटल एविडेंस को कैसे प्रेजेंट करना है, कैसे इलेक्ट्रॉनिक एविडेंस कोर्ट की फाइल में एक फिजिकल एविडेंस बन जाता है. उस जर्नी को जरूर समझिएगा. दैट विल बी डिस्कसिंग. तो evidence is the backbone and digital evidence is the backbone of all the cybercrime prosecution. जितने भी cybercrime cases we are dealing, digital evidence is the backbone of all these cases that we are looking for. एक बात याद रखिएगा, जैसे हर क्राइम के पीछे कोई ना कोई एविडेंस होता है. सेम in a I'll say cybercrime, every evidence or someone leaves a digital footprints. हर डिजिटल एक्टिविटी के पीछे एक डिजिटल फुटप्रिंट्स होता है. फुटप्रिंट्स को आप समझिए एक एविडेंस की तरह हम कैसे यूज करेंगे. अब इसमें क्या क्या चीजें आती हैं. द फॉर्म्स ऑफ एविडेंस कैन बी ईमेल्स, चैट्स, सोशल मीडिया, सीसीटीवी फुटेज, मेटाडाटा, सर्वर लॉग्स एंड योर ट्रांजैक्शंस रिकॉर्ड. दीज आर द रूटीन फॉर्म ऑफ एविडेंस जो हर कोर्ट की फाइल में मिलेगा. I repeat, email, chat, social media, CCTV footage, metadata and transactions, your transaction records. These are the routine forms of evidence. ये हर कोर्ट की फाइल में on each and every case you will find it. Now in introduction, when I talk about digital evidence journey, understand this point कि असली टॉपिक ये नहीं है कि digital evidence है भी कि नहीं. किसी एक केस में मे बी देयर मोस्ट ऑफ केसेस यू अंडरस्टैंड देयर इज नो डिजिटल एविडेंस. तो असली टॉपिक ये नहीं है कि डिजिटल एविडेंस इस केस में है भी या नहीं. असली टॉपिक ये है कि एविडेंस कैसे कलेक्ट होता है, कैसे प्रिजर्व होता है और उसको कोर्ट में एडमिट कैसे करवाया जाता है. दीज आर द 3 keywords you understand the journey of digital evidence: collect, preserve and admit. So CPA, you can understand this point. CPA is the journey, collect, preserve and the admit. कुछ केसेस में हम कोर्ट पहुंचने से पहले ही हम केस हार जाते हैं. Why? Because the real evidence वो कभी कोर्ट में पहुंचता ही नहीं है. The real evidence is missing from all the court files, and that is what this session is about, कि एक डिजिटल एविडेंस को कैसे कोर्ट की फाइल में प्रिजर्व करा जाए और कैसे उसको एविडेंटरी वैल्यू में पेश करा जाए. So you can see all the metadata, CCTV footage, introductions. These are all the introduction that we'll be discussing. Please change it to the next slide. Okay, slide number 4. These are the evidentiary pitfalls. You are on the correct slide. Evidentiary pitfalls, you can see what are the failure जब हम किसी एक digital evidence की journey में आते हैं. What are the speed breakers or what are the pit holes that we should discuss. The first is the failure to maintain the chain of custody. As I tell you, digital evidence की एक journey होती है. So understand the source. Source is the birth. कि एक digital evidence कहाँ से निकला है? What is its source? Or then from where, from the source they have traveled. जो भी digital evidence अपने source से थोड़ा सा भी travel करके आएगा, they will make a chain of custody. So उस पूरी chain को आपको prescribe करना है एक manner में, ये दिखाना है कि इस journey से ये digital evidence निकल के आया है. And what would be the result of it? Reliability and authenticity of that digital evidence is considered or presumed as authenticate. The next one is the improper seizure of electronic devices. आपने बहुत सारे cases में देखा होगा that police department, what they do, they seize most of your electronic devices. The catch is most of the time the police or the department, the investigation department, what they do improper seizure of your electronic devices, and that is also a failure of a digital evidence. Lack of forensic imaging before examination, the third point. जो भी evidence कोई भी organization, कोई भी authority collect करती है, they should, the next stage is to send them to the forensic. And forensic में there are two stages, before examination and after examinations. Understand this point. जो भी digital evidence एक बार forensic में गया, there are two stages, before and after. And 99% of the cases forensic में before and after की दोनों की report नहीं बनाई जाती है, and that is also a procedure where the evidence fail. The other one is delay in preservation, alteration of metadata and delay in preservation. Metadata is basically all the details जो किसी hash value और जो कि किसी evidentiary electronic record में है, अगर उसको alter किया जाता है या उसकी preservation में delay होती है, that is also an evidentiary pitfall in our case. Absence of hash value, we'll discuss in the upcoming slide what hash value is and how important it is. उससे पहले हम ये समझेंगे what is primary and secondary digital evidence. उसके बाद हम hash value verifications के ऊपर पढ़ेंगे. Incomplete server log, audit trials. This is the most important thing. कोई भी investigation agency इन दोनों चीजों को पे ध्यान नहीं देती या इसको बिल्कुल ही ignore कर देती है, which is audit trials. As I told you, digital evidence is a journey. तो हमको सबसे पहले what is the tip to get the digital evidence? सबसे पहले आप source को समझिए. Understand the source of the point. And that is what audit trial is. कि उसका trial क्या है, वो source value से कहाँ निकल गया है. That is what audit trial is. And the next one in the slide, the last one, non-compliance with the certificate requirement. We'll also discuss what the statutory requirement in court. Please change the slide. We go to the next slide. So here, this is the evidentiary pitfalls. Before I'll tell you the digital evidence, I'll tell you there are two type of evidences. हम सब ने evidence act में पढ़ा होगा. If you are one of the law students or a practicing professional, this is one of the most important digital aspect. Primary and secondary evidence. तो दो तरह के evidence होते हैं, primary and secondary. There is in digital, in cybercrime cases, we'll say PDE, which is primary digital evidence, and SDE, which is secondary digital evidence. So there are two kinds of evidence, primary and secondary. Let's discuss what is primary. Primary हम कहते हैं ओरिजिनल एविडेंस. कोई भी एक रॉ फाइल और विच इज इन ओरिजिनल format, the original file stored in your device is the primary digital evidence. सबसे पहले where it was file was created or maintained. Primary digital evidence में सबसे पहले हमें यही देखना है where the file is created and where it is maintained. Let's say most of the file is maintained in your hard drive, SIM cards or server log data. Any device you are using server log data उसमें होते हैं. BSA has a mandatory requirement of digital or video recording. जो भी एजेंसी BSA में एविडेंस कलेक्ट करती है और उसे सबमिट करती है, which says automated video and digital record. अब एक बात याद रखिएगा कि if digital और video records multiple files में होता है, so can anybody of you tell कि अगर वो मल्टीपल फाइल्स में या मल्टीपल स्पेसेस में है, will it be considered a primary digital evidence? Yes or no, chat box, or raise your hand in thumbs up if you say yes, which I'll be answering soon. Second, let us discuss in the secondary one. Let me see if anybody is saying yes. Okay, so there mixed reaction. App question tha. I'll tell you why. BSA specifically says, अब एक बात को बहुत आराम से समझिएगा, प्राइमरी डिजिटल एविडेंस वो होता है जो उसकी, मैंने सबसे पहले बताया, ओरिजिनल और रॉ में होना चाहिए, जो आपकी डिवाइस में सबसे पहले स्टोर हुआ है. दैट मीन्स द सोर्स जहां से वो फर्स्ट क्रिएट हुआ. अगर एजेंसी कोई भी वीडियो रिकॉर्डिंग और कोई ऐसा एविडेंस शेयर कर रही है जो मल्टीपल फाइल्स में है या स्टोरेज स्पेस में बहुत ज्यादा है, तो उसका जो स्टोरेज स्पेस होगा वो मल्टीपल फाइल्स कंसिडर होगा. द आंसर टू दिस क्वेश्चन इज दैट मल्टीपल फाइल digital evidence will be considered as a primary digital evidence. Why and how? जब मल्टीपल फाइल्स में डेटा होता है उसको प्राइमरी तब कंसिडर करते हैं, एवरी फाइल विल बी कंसिडर एज अ प्राइमरी डेटा. तो हर फाइल, हर सोर्स में उसको प्राइमरी डिजिटल एविडेंस की सोर्स अकाउंट में ही अकाउंट करेंगे. दैट इज वन ऑफ द कैच. टू अंडरस्टैंड दिस पॉइंट, अगर वो ओरिजिनल फाइल स्टोर्ड आपके डिवाइस में है जहां से वो क्रिएट हुई है, इवन इट इज इन मल्टीपल फॉर्म, इट विल बी कंसिडर्ड एज प्राइमरी डिजिटल एविडेंस. फटाफट सेकेंडरी पे आते हैं. सेकेंडरी बहुत सिंपल है, किसी भी ओरिजिनल की कॉपी, प्रिंट आउट, स्क्रीनशॉट या उससे एक्सट्रैक्ट करा गया एविडेंस इज अ सेकेंडरी एविडेंस. ज्यादातर डिजिटल एविडेंस या साइबर क्राइम केसेस में कहां से यूज होता है? ईमेल्स और क्लाउड डेटा और सर्वर डेटा. ज्यादा से ज्यादा सेकेंडरी एविडेंस इन तीन सोर्सेस से आता है और ज्यादा से ज्यादा इन सोर्सेस से ही हम सर्टिफाइड कॉपी कोर्ट में एडमिसिबल कराते हैं. जितने भी एविडेंस हैं उसकी सर्टिफाइड कॉपी जाती है. दैट इज कंसिडर्ड अंडर सेकेंडरी डिजिटल एविडेंसेस. सो आई बिलीव प्राइमरी और सेकेंडरी डिजिटल एविडेंसेस में आप सब समझ गए होंगे. वी कम टू द स्लाइड ऑथेंटिसिटी एंड एडमिसिबिलिटी. अब हमने जर्नी में सबसे पहले क्या समझा? सोर्स समझा. सोर्स प्राइमरी और सेकेंडरी दोनों में से आ सकता है. वील कंसिडर प्राइमरी हैज अ प्रेफर्ड और you can say a stronger digital evidence value. Secondary have a weaker digital value. In this slide, our next step is authenticity and admissibility. I'll tell you one most understand in this point. Authenticity and admissibility. IT Act and BSA says every evidence is authentic and reliable and credible. In this case, इस IT एक्ट और BSA में जब ये बताया जाता है कि एवरी एविडेंस इज ऑथेंटिक, रिलायबल एंड क्रेडिबल, इससे हमें क्या समझ में आता है? इससे हमें ये समझ में आता है वट एवर द एविडेंस दैट वी आर सबमिटिंग इन कोर्ट, कोर्ट विल प्रिज्यूम दैट दिस एविडेंस इज ऑथेंटिक. एक ऑथेंटिक सोर्स है, एक रिलायबल डेटा सोर्स से आप इसको प्रेजेंट कर रहे हैं कोर्ट में, एंड दैट इज द रीजन व्हेन इट ऑथेंटिक एंड रिलायबल द कोर्ट विल प्रिज्यूम इट्स credibility. But the point is, अगर लॉ में ये लिखा गया है तो दैट मीन्स एविडेंस आते ही कोर्ट ये प्रिज्यूम कर लेता है कि ये क्रेडिबल है, विच इज अ राइट पॉइंट. इन केसेस में आप प्रिजम्पशन को कैसे हटाएंगे? देयर इज ओनली अ वन ट्रिक, बहुत सिंपल लॉजिक है. इनके बीच में कोई भी एरर, कोई भी गैप हो गया जहां से आप इसको डाउट कास्ट करा सकते हैं. एनी गैप, एरर और अ डाउट इन सच on its credibility, this weakens the digital evidence, and as a result the accused walk free from the court. So understand this point. हर evidence जो भी कोर्ट में जाता है उसकी presumption होती है. The court will not presume this evidence as a predatory evidence. पहले से ये मान के नहीं चलेंगे कि ये this is authentic and reliable from all the sources. So we understand. मैंने slide शुरू और ये presentation शुरू होने से पहले I'll tell you about the journey pre and post era. मैं यहीं पे pre and post era के बारे में discuss कर लेता हूँ before jumping into the authenticity and admissibility. Indian digital evidence journey has two stages, pre and post. To make it very simple for you, I see the questions are there. I'll be answering in the same session. Journeys को समझ लेते हैं. Take if you have pen and paper, please note down these informations. ये informations कोई नहीं बताएगा. These are most important information. Digital evidence को आप दो stages में, दो eras में divide कर लें, which would be very easy for you to understand the digital evidence journey. The very first stage is a pre-2000. 2000 से पहले की journey where the digital evidence is treated with IPC and Indian Evidence Act of 1872. What the IPC and the Indian Evidence Act do, they give us the limited provision on digital evidence. The IPC and Evidence Act have only limited provisions. अगर आज भी आप खोल के देखेंगे, there's only number of few handful provisions जो digital evidence की बात करता है, उनकी authenticity की बात करता है. Then came in 2000 an IT Act, which give the recognition to the electronic record. And अगर आपको थोड़ा सा डिटेल में जर्नी समझनी है, understand and read the section 43 to 66. You can note down section 43 to 66, which provide us the number of provisions, which provide us the horizontal of the digital evidence, जिसने इस गैप को कम करा और एक wide horizontal presentation दी for these evidences and provided us evidences of cyber offenses. उससे पहले IPC Indian Evidence Act में cyber offenses के लिए कोई भी provisions directly relate नहीं किए गए थे. That is why this IT Act 2000 gave us the recognitions. This is the pre-era of 2000. Now we go to the next stage, 2002, जहाँ पे IEA Indian Evidence Act की amendment हुई and added section 65A and 65B. Same, अगर आप BSA में पढ़ेंगे, most probably it is section 61, 62 and 63. So 61, 62, 63 and 65A and 65B, which was the Evidence Act, largely they are similar to the Indian Evidence Act. Now what it says is journey में समझना ये जरूरी है. The law has evolved with the technology, but our act have not amended yet. तो law तो amend नहीं हुआ, लेकिन technology involve हो गई, and that is why to cope up with BSA and IT Act give you the chances, the stages of admissibility of digital evidence. This is what we'll be discussing in the next few slide as well. Please change the slide. Okay, I'll just see if there's any questions. Is the authenticity described or defined by any code for better understanding? Okay, the Neha asked this question. Neha will be answering in the last of the slide. Authenticity को कैसे एक digital evidence को एक कोर्ट की फाइल में एक physical evidence बनाया जाता है, I'll be discussing in the next few slides. Okay, the someone says, sir, in your experience, can you share a cybercrime case where seemingly insignificant piece of digital evidence completely changed the outcome of the trial? What practical lessons should be? Okay, I'll be discussing it with the one of the few landmark cases of mine that we have discovered, and कहाँ पे digital evidence की insignificant piece की वजह से we lost or we won the case. At the end of this section, practical advice to the young lawyers who will expertise. Okay, I think it's very soon that you are asking the tips and tricks. Let us get back to the slide. Okay, this slide, which I discussed section 61 and 63 of BSA in detail. Indian Evidence Act 65A, 65B, these are correlated and similar. BSA just streamline this process ताकि admissibility of the electronic evidence को easy करा जाए. Get into the stages. Legal framework, दोनों का composure mix करके Indian Evidence Act and BSA को composure को mix करके I'll tell you the final conclusion of both of these two acts. 65A says electronic record deemed proved माने जाएंगे जब वो कोर्ट में आएंगे. 65A says deemed proved. You can just write out 65A which says deemed electronic record deemed proved. 65B says detailed likes device. 65 में there's a list of the details जो कोर्ट आपसे पूछता है. Let's say device, source, regularly used, information को कैसे स्टोर और प्रोसेस करा गया, information ordinary course में कहाँ से चेंज हुई, what was the journey, streamline में कहीं प्रॉब्लम है, which system से फॉरेंसिक रिपोर्ट बनी, कौन सा सिस्टम उसकी फंक्शनिंग के लिए. मैंने शुरू में बताया था कलेक्शन एंड प्रिजर्वेशन. डिजिटल एविडेंस की जर्नी में ये दो स्पीड ब्रेकर्स हैं, और 65 भी उसी लूप होल को थोड़ा सा एग्जैजरेट करता है एंड आस्क अबाउट द सिस्टम फंक्शनिंग. आउटपुट एक्यूरेट इंफॉर्मेशन, दैट द इंफॉर्मेशन स्टोर्ड, उस आउटपुट को हमने कैसे लिया गया है, एंड all this information we have to submit in a court in a form of a certificate, which is a 65B certificate. And also some of the certificate which forensic expert gave us, it's come under the provision of 65B. And now I'll tell you one of 63 BSA. Yes, BSA में 65B को कैसे डील करा गया है. So you have to provide an affidavit as well as in a certificate in BSA in a prescribed format. There's a format given by the court. उस format में when you give all the information related to system functioning, accurate reproduction, storage कहाँ, process कहाँ करी गई, information store कहाँ करी गई, what was the streamline course. If you fail here, understand this point, if you fail here, the evidence dies. So digital evidence की journey में this is a non-negotiable stage. If you fail here, the evidence dies. And that is why 65A, B, 61, 62, 63 of BSA is most important stage where admissibility के ऊपर हमको इस procedure और इस prescribed form से गुजरना ही होगा. Please change it to the next slide. Now I'll tell you one of the most misconception about the digital evidence. This is from my personal experience. I'll tell you one of the most greatest and the most dangerous misconception in legal practice. Digital evidence की journey में सबसे बड़ा dangerous and misconception क्या है? That if a digital document is admitted into an evidence, it automatically accepted as authentic. To understand this point, कोई भी digital document को कोर्ट में जब एज एन एविडेंस एडमिट करते हैं वो ऑटोमेटिकली ऑथेंटिकेट माना जाता है. दिस इज वन ऑफ द मोस्ट इंपॉर्टेंट मिसकंसेप्शन. ये मिसकंसेप्शन है, दिस इज कंप्लीटली फॉल्स. अंडरस्टैंड टू बेसिक टर्म्स. लॉ इतना मुश्किल नहीं है, देयर इज ओनली इंग्लिश टर्म्स. थोड़ा सा उसको स्पेसिफाई करो एंड अंडरस्टैंड द बेसिक कॉन्सेप्ट. Admissibility is the first stage, authenticity is the other stage followed by admissibility. So सबसे important क्या हुआ? Admissibility. If admissibility procedure is correct and true, the authenticity will be presumed. These are the two distinct terms but operated sequentially. Distinct terms हैं लेकिन sequentially में ही we consider this as an authenticate and credible information. Now in this slide, the Supreme Court, the Honorable Supreme Court repeatedly emphasized that a statutory certificate, which is a prescribed format given by court, opens the courtroom doors to establish the admissibility. जो format में हम certificate दे रहे हैं, it only establish the admissibility. जैसे ही हम उस evidence को admit करवा देते हैं, then it comes to the question of authenticity, and that is what a smart or a senior or a smart advocate, I'll say, understand and attack this point. Admit हो गया इसका ये मतलब नहीं कि जो भी evidence admit हुआ है, we presume the authenticity. No, understand this point. Admit हुआ वहाँ digital evidence can be altered, can be manipulated, or fabricated. There is a three situation we presume that there can be an alternation, manipulation, or fabrication of that evidence which is already admitted in the report. So the Supreme Court says, in order to understand the admissibility of the evidence, we should corroborate with the forensic report, or we should corroborate with the contents which are genuine on this digital electronic evidence. So you must achieve both. Understand, admissibility and authenticity. In order to win your case, you have to win both of them. And remember, one most important point, you can note down this point. Admissibility only establish that the record is legally permissible to be evaluated, but not prove. Understand this point, that the admissibility is a record that is legally permissible but not proved. सिर्फ उसको record purposes के लिए permissible करा गया है लेकिन proved नहीं है. So at any stage of a case, you can raise question, controversy on its content, on its authenticity, but not on its admissibility. Admissibility का एक prescribed format है. जैसे ही वो format और वो steps आप ले लोगे, वो digital evidence admit हो जाएगा. लेकिन authenticity पे you can challenge at any stage. And to make your case even stronger, target both the points. You have to achieve both in order to win your case. This slide just talk about the same. Please change to the next slide. And one of the most important point is the contents. If our contents of the electronic evidence are accurate and not being tampered and not trustworthy, that document is admitted and the authenticity is presumed. So सबसे harder जो test है वो authenticity का है, admissibility का नहीं है, authenticity का. And document can be admitted but cannot be presumed authentic in such case. So always raise question on the genuineness, integrity, and the contents of a digital evidence. In this case, we'll talk with the email evidence and CCTV footage. Just not to give you a book knowledge, I'll give you one of the examples. Let's say, consider an email evidence. You produce an email evidence which is flawless with the electronic certificate, a printout of it. So understand, email secondary evidence, email की एक certified copy, एक certificate के साथ, print out के साथ हम कोर्ट में उसको जमा कर देते हैं. Now understand, that copy with our certificate, will that be admissible or will that be presumed authentic? अब ये chat box में बताएं what would be the core subject of this email. Then I'll tell you what this thing says. So if you produce a flawless, I'll repeat the question, if you produce a flawless electronic certificate with the printout of the email, will it consider an admissible or will it consider admissible and authentic? Any of the two words in your chat box. Someone says admissible, admissible but not necessarily authentic. Admissible but not authentic as of now, you must know the authenticity. Admissible, correct. Authentic. Okay, perfect. The people who says admissible are true and okay, they understand the concept. The people who says the admissibility, I right now told you कि admissible जब होता है उसकी presumption होती है. हम ये नहीं मान के चलेंगे कि जो भी evidence कोर्ट फाइल में आ रहा है वो authentic है. अभी I'll just repeat once again, which I repeated in the last slide. At any stage, raise question on the authenticity, on the content, and on the genuineness. जब ये 3 stages, ये एक तरह का टेस्ट समझ लो. जब इस टेस्ट से एविडेंस बाहर निकल जाएगा, it will be said as authentic. So I believe this is clear to all of you. अब अगर सेकंड स्टेज में हम सीसीटीवी फुटेज की बात करें, I have let's say video file with a proper certification. एक वीडियो फाइल प्रॉपर सर्टिफिकेशन के साथ मैं कोर्ट में एडमिट करा देता हूँ. According to your last answer, it will be admissible but not authentic. Correct. But a defense policy expert highlight. अब यहाँ पे understand with my previous case experience, footage was on the record in a murder trial. Murder trial. अब इस बात को बहुत गौर से समझना. This is one of the stages where I raised controversy. Footage. It was a primary evidence, but I raised the controversy. What the prosecution says, there was no one in the room.
Sir, excuse me, sir.
Yes.
Sir, your voice is not audible.
Is it audible now? I believe everyone.
No, sir.
I'm sorry, my network connectivity,
Yes.
but once again.
Sir.
Am I audible now?
Yes, it's clear.
Okay. Let me repeat once again. Says no, please check. Yashwant, am I audible?
Sir, now, sir, can you speak now, please?
Am I audible? Right?
Yes, sir. Now it's clear.
Much clear. Perfect. I'll tell you the example of CCTV footage in my case. Yes, sir, you are audible. Perfect. Thank you. In my case, the situation was it was a murder trial. CCTV footage was submitted by the prosecution. And what I argued, CCTV footage में सिर्फ ये था कि there was room closed, murder happened, entry and exit. Accused की time stamp entry 10 मिनट पहले accused ने entry ली और 10 मिनट बाद accused ने exit ली. इतनी सी CCTV footage prosecution ने submit करी. Now tell me, what would you consider is authentic with the certification? सब कुछ करके हमने दिया है. Do you consider that CCTV footage as an authentic? Yes or no? Okay, please type in your answer. No. Okay, someone says no, someone says yes. I believe there is confusion, but which I'll any more answers or I'll answer you the conclusion right away. No, there could be some edits from the time interval of the murder. Okay, no. Okay, I'll tell you. If a defense forensic expert, हमने क्या करा? हमने missing frames को highlight करा. And we asked जो 10 minutes का time stamp था, why the prosecution, let's say the prosecutions from 10:40 to 10:50, एक continuous CCTV footage क्यों नहीं submit करा by the prosecution? It 10 minutes का जो time stamp था, it will be admissible but not authentic. Okay, so in this case, court rejected the CCTV footage. You understand? Next slide. Please change to the next slide. Previous slide before to this one. It says bank transaction. Correct. Digital transaction में 50% of the cases of the bank fraud scams सारे के सारे cases इसी के होते हैं. Now understand this point. bank statements, ledger records are easily admitted under proper electronic evidence and with the bank. जितने बैंक स्टेटमेंट्स and ledger records हैं, वो easily admit हो जाते हैं. But अगर forensic, when you deep dive into the access of the hash value of these contents, you will understand administrative access or backdated data manipulation से केस ब्रेक होता है. So, understand this point? Bank transaction record में, if you go for forensic, backdated data manipulation the case break. Social media, social media post, understand this point. Social media post, screenshot, at least होते हैं, but it's can Google.
Sir, excuse me, sir. Sir, excuse me. Sir, your voice breaking. Can you please check?
Sorry, I'll be very close to the mic and
Yeah, it's clear now.
I'll be very close to the mic. Please ignore my video.
Yes.
Or for a second, I'll just stop my video. Let's see the voice quality. Now I believe my voice quality will be more aggressive. Okay. Social media post. क्या कोई बता सकता है कि सोशल मीडिया पोस्ट में what would be your contention कि सोशल मीडिया पोस्ट में these can be the things which जो उनकी authenticity के ऊपर डाउट रेज कर सकती है. Any suggestions? Social media post, what can be the things which raise issues of authenticity? Any guess? In chat box. One of the cases, I'll give you a brief. One of the cases, social media post was submitted in the court, and the accused says that the social media was cloned or fake, or I lost the password. So indirectly, they said that I lost the access of my account. That means the authenticity. The electronic evidence is edited, but the authenticity is valid. In this case, the court have no option to understand this point. When something was not in your control, it cannot be authentic. That was challenged, and the court concluded that social media post was authentic. Next slide, please. The next slide. Reservation. Now I'll tell you the evidence preservation. Let me make it easy for you and directly tell you. The first one is improper chain of custody, where failing to maintain the unbroken chain of custody. Proper chain of custody break हो जाएगी, or you raises the controversy which implies.
Sir, excuse me, sir.
Yeah.
Sir, your voice is not audible again, sir. No, sir, like it's breaking, sir.
Anybody please says everyone I'm audible, just a thumbs up will do fine. I'll
Yes, sir.
continue. Perfect.
It's fine.
In this slide, I'm directly telling you about the chain of custody. Chain of custody में who handle the device, when, where, how, and under what conditions. Please note it down these set of phrases. Who handle the device, when, where, how, and what conditions. When you raises controversy on these points, the improper chain of custody will be established. In this case, whenever a police take your device, कोई भी पुलिस आपसे आपका device without proper notice और proper checking के बिना जब लेती है and then they seal into the bags, logs, that is the improper chain of custody. Anything, कोई भी evidence, especially electronic evidence, if it is not from the right source or right channel, it is under the improper chain of custody. So I'm just telling you the problem that you will face. The second one is the lack of timely seizure and preservation. कभी भी preservation के time में difference है, time delay है, that is also under the improper and delay seizure. So that could be the second problem. Third one is most of the time data disappear when the power is cut. If we talk about cloud server, cloud infrastructure, remote deletion से भी access हो सकता है. In this cases, end-to-end encryption, passwords, auto deletion, chat apps, आपने देखा होगा बहुत सारी chat apps में auto deletion का process है. And also many of the applications give you the access to intentionally wipe out your data. So these are the hurdles, these are the pitfalls that we face in electronic evidence. कोर्ट पहुंचने से पहले the electronic evidence is missing. That is one of the pitfalls in this evidentiary value. The next slide. Now I'll tell you what would be the best practices. Best practices mein, I told you what would be the problems in preservation. Now I'll tell you what would be the best practices for the preservation. The special one is there is a technique in US. You can understand there is a technique in US. जब भी forensic के लिए कोई document जाता है, they call them gold standard forensic practices. So they have a test of gold standard to check the forensic records to electronic records, the images used to create an hardwire. So उस golden standard के I'll give you tips. Forensic images का एक backup, hardware overwriting, original data that was saved in a fraction of byte. This is one of the best practices to save. Immediate preservation is one of the best practices. Second, the document to have a backup in many of the channels. जैसे मैंने सबसे पहले ये बताया था, primary evidence अगर multiple forms में हुआ, every form, every device where you will store, it will consider as a primary data. So हर एक data whichever you are saving, immediately take its backup and it will be considered in multiple device as a primary preservation technique or a primary data. Get to the next slide. We'll be discussing in detail the best practices for preservation. Now you can see an immediate forensic image of the device on your screen. Issue preservation notice to intermediaries using right blocking tools to prevent modification of original data and calculating and documenting hash value. Right now I told you that a fraction of byte can be altered. So हर एक byte is called an hash value. Every image you have उसमें pixels होते हैं. Understand this point. What is a hash value? Every image have pixels. Every pixel have in this image is called a byte. So every pixel has a byte. अगर किसी एक byte में भी change है और वो altered है या corrupted है, that hash value will be considered as inauthentic. Admissible हो सकती है but inauthentic हो सकती है. Do not get confused in any of these words. बहुत simple English है और बहुत reasonable operative understanding है इन दोनों words की. So the immediate evidence preservation is the backup and you take up in multiple devices. That is one of the best practices of preservation. Next slides. The legal framework which I have discussed, BNSS and IT Act 2000 This is one of the two act that deal with the digital electronic record. 61, section 61, section 62, section 63 of BNSS, and Indian Evidence Act is section 65A, section 65B. Most important sections legal framework के लिए in accordance with the digital data is these sections. And also in IT Act there is a procedure called search and seizure protocol. So whenever an investigation agency will ask for a forensic data or an evidence, जब भी वो evidence collect करेगी, they will give you a notice of search and seizure. If there is no notice or there is an error in order to take the evidence, understand this point, even if the evidence is correct, but उसके लेने का procedure illegal है, then also it challenges the authenticity. Illegally, you cannot take the correct or legal electronic data. That is also one of the most important points. This is a key takeaway. If you fail to preserve the digital evidence at the earliest point of contact, there can be a loss or a permanent loss of data, which I told you to take a backup immediately. If we cannot preserve the data, most of the investigation agency, they fail to preserve the data immediately. And that is why the authenticity and admissibility in the courtroom of these investigation agencies always challenged. The next slide in this case. Now moving to the fifth pillar, forensic evidence. Forensic evidence includes digital forensic reports, which serves you as a purpose on objective and cybercrime science. So every forensic evidence is backed or supplemented by a forensic report by the investigating agency. Now, what this report includes? This report includes binary data, files, audio, video, images, certified labs, and the hash value, which I just written in the form of file. Forensic report, every forensic digital evidence, all this file. Now you understand in the next step as important point is
excuse me, sir. Sir, your voice is not audible right now.
Okay, I believe I'm in the network range and my voice would be audible.
Yeah, it's audible.
Perfect. I apologize for this.
Yeah, no problem, sir. Thank you.
Okay. So I'll explain you the most important point in this slide is forensic evidence में there are two parameters, before and after. You can please note it down, before and after. कोई भी evidence forensic report में forensic lab में जाने से पहले the forensic evidence or expert have two important jobs, before and after. Evidence पेश होने से पहले उस evidence कैसे वो प्रिजर्व था और किस कंडीशन में वो प्रिजर्व वो एविडेंस फोरेंसिक में आया, उसकी एक रिपोर्ट, दैट इज अ बिफोर रिपोर्ट. रिपोर्ट एग्जामिनेशन बनने के बाद देयर इज अनदर रिपोर्ट दैट द फोरेंसिक एक्सपर्ट विल मेक व्हिच सेज एग्जामिनेशन होने के बाद व्हाट वुड बी द चेंजेस एंड हाउ अगेन द डेटा इज बीन प्रिजर्व्ड. लेट्स से in most of the cases, investigation agencies envelope में डाल के CD or DVD or a pen drive, they send it to the forensic department. Now the condition is the forensic department will open that envelope. That will be a sealed envelope. Again, when the envelope is open, the forensic evidence is examined. Again, the forensic expert will the same CD, DVD, or a pen drive, or an image, or a video, they will again put it in the same प्रिजर्वेशन मोड, जिस मोड में वो सीडी आई थी उसी मोड में वापस उस प्रिजर्वेशन मोड में उस एविडेंस को डाला जाएगा. एंड दैट इज व्हाई बिफोर एंड आफ्टर आई एम टेलिंग यू द टू स्टेजेस. एविडेंस आने से पहले और एविडेंस की एग्जामिनेशन के बाद व्हाट आर द चेंजेस और कैसे उसको प्रिजर्व करा गया है. If you understand this point and you create a controversy in this point, I'll give you the guarantee at least 70% of this time you will find the authenticity of forensic evidence report is also and can be challenged in court with this procedure. Now understand this point. कोई भी एविडेंस, डिजिटल एविडेंस एक परफेक्ट फॉर्म और एक परफेक्ट शेप में नहीं होता. डिजिटल एविडेंस इज इन अ डायनामिक फॉर्म, इट इज इन अ फ्रेजाइल फॉर्म एंड इट इज ऑल्सो हाईली वर्नरेबल. उसको कभी भी चेंज करा जा सकता है. अ वॉलेटाइल डेटा कैन बी चेंज्ड. You understand, RAM, caches, and check files, all these data can instantly disappear. ये सारे डेटा जो instantly disappear हो सकते हैं, क्लाउड डेटा जो रिमोटली भी डिलीट हो सकता है, योर पासवर्ड प्रोटेक्शन, इंक्रिप्शन एंड मल्टीपल डिवाइसेस में जब कंट्रोल्स होता है, that can disappear instantly. And that is why इसकी एक check value रिकॉर्ड करी जाती है when they are sent to the forensic evidence. And in these cases, two things are most important: before and after report and jurisdictional delays. किस jurisdiction में कितने टाइम फ्रेम में वो forensic evidence को रिकॉर्ड और एग्जामिन करा गया है, ये बहुत अच्छा controversy और challenging point है. You can raise controversy on these 2 points. Please change it to the next slide. Okay, forensic report, what it reveals, you can see it's a very simple thing. Emails, browser history, deleted files, network instructions, hash value. But if you are using a phone, mobile phone model, IMEI number, SIM card, कौन सी कंपनी का SIM card है, all these things forensic report includes. The next slide, please. Evidentiary value, I just told you about the digital evidence is dynamic and it can be remotely encrypted, password protection, they can be challenged, controversy can be raised and can be instantly deleted. Next slide. For the evidentiary value, this is the most important slide. For an advocate, what would be an effective way to present the evidence and to talk about its credibility as well? In a way of an effective litigator, एक advocate के हिसाब से, the most critical aspect is to keep an eye on the investigation. There is no rocket science. 2 चीजों पे ध्यान देना है: forensic evidence का source, forensic evidence की journey, and the same source, journey and forensic evidence जब examination के लिए गया, before and after journey. These 3 conditions with a advocacy perspective, एक advocate के perspective है, you can talk and create the doubt of its credibility in the court of law. The next slide. Practical lessons. Practical lessons is one of the best practices. I gave you the tips and trips. Best practices कौन सी होगी to preserve the digital evidences? Practical tips would be: power off ना करें, do not immediately power off your devices, always have a backup, and make sure that you have a backup in 1 or more devices, because every device you backup will have your primary evidence value. And also keep it password protected, change your password every 90 days, I'll say 3 months, and make sure that all these evidence or all these data should be stored that only you can access it, no third person can access it. These would be the practical lessons or the practical tips in order to save or preserve the forensic evidence. The next one, judicial trends. Next slide, I'll directly talk about the judicial trends which is discussed by the honorable courts in this case. The next slide, please. There are the landmark judgments that we have The next one. All the three landmark judgment that we'll be discussing in the judicial trends. Next one, I believe, please, the next slide.
Sir,
We'll be
should I
discussing in
go,
detail.
like previous one,
The next one, the number 24 on the
24.
right.
Okay.
Yes,
Yeah.
perfect. Anwar PV and PK Bashir 2014, that is one of the landmark judgment related to electronic evidence. In this case, all the electronic evidence was secondary evidence. Understand this point, primary evidence पेश नहीं करा गया था इस case में. All the evidence was a secondary evidence which was accompanied by the certificate 65B जो कि mandatory requirement है, which we already discussed. Now, the most important findings from this case is the Supreme Court clarified that electronic evidence has a distinct category of evidence governed by these special provisions, which is I told you about the IT Act and which I told you about the BSA, which is you can see section 63 and section 65, the above line. The secondary evidence cannot override this requirement. That means किसी भी केस में आप अगर एविडेंस को एडमिट कर रहे हैं, then these value cannot be override. These are the most important and the mandatory requirement in order to admit a case and to talk about its authenticity. You can make note of this case, Anwar PK and PK Bashir 2014, and concluded by the Honorable Supreme Court. The next slide. On the right one, the next slide. Yes, Tommaso Bruno. This case is one of the famous and a landmark case under the name, it is known under the name of Tommaso Bruno. Supreme Court highlighted the importance of a scientific and electronic evidence, which we have discussed, the byte, hash values, जो भी ऐसी scientific terms हैं electronic value के, this was discussed by the Supreme Court in this case, basically related to two things, CCTV footage and the digital recording. दो चीजों के ऊपर सुप्रीम कोर्ट ने इस केस में बहुत ही डिटेल वर्जन में अपनी फाइंडिंग्स दी हैं. सीसीटीवी फुटेज कैसे यूज होगी आने वाले केसेस में, एंड हाउ अ सीसीटीवी फुटेज and digital recording can be presented in court. So if the most important finding in this case was the investigating agency fails to collect the data in a prescribed manner, then that electronic evidence will be considered as a weak electronic evidence, and as a result it will weak your case for a fair trial. That was a guideline given by the Honorable Supreme Court in Tommaso Bruno case, which was of 2015. The next one, all these the fundamental contents of this case we have already discussed in the last slides. The right one, the next slide. Shafi Mohammed versus State of Himachal Pradesh, 2018. This was discussed by the Supreme Court. The main important finding in this case was the 65B certificate mandatory requirement. The Honorable Supreme Court says the 65B certificate की एक mandatory requirement है. It cannot bypass. So from which source you are taking the digital evidence, वो सब record करना है, and you have to tell exactly from which source and what was the source of preservation and why the evidence was admitted. इस source के बिना it cannot bypass all the prescribed data of 65B. 65B एक mandatory provision है. Without it, any evidence cannot be sent to the doorways of the court files. कोई भी electronic evidence, physical form of evidence में तब तक count नहीं होगा जब तक वो 65B और in today's case 63 of BNS Act. So this was the important finding by the Honorable Supreme Court in Shafi Mohammed case. The next slide. All these cases gives us only one scenario, that the digital evidence is the backbone of the cybercrime cases, and all the data, admissibility of the data is an expert evidence which covered by the Evidence Act, BSA and the IT Act as well. So understand this point, digital evidence data supplements your case. Now, Arjun Pandit Rao, Savarkar case is one of the landmark judgments as well. It is one of the recent judgment of 2020, where the Honorable Supreme Court lays down the principle and overruled the Shafi Muhammad case we have just discussed. Shafi Muhammad case को overrule करा गया, and 65B is a journal mandatory requirement of the secondary data. But in this case, is why it has been overruled, because WhatsApp messages, email, CCTV footage, TDR records, and social media, also the digital transaction that we are doing these days, these are under the framework of the digital evidence, and that is why 65B में इन सबका data, इन सबकी source information and the admissibility authenticity can be challenged without if we bypass section 65. Now understand the Arjun Pandit Rao is one of the recent judgment. इसी judgment के ऊपर most of the data admissibility is being recorded in the court these days. The next slide. State of Karnataka, this is one of the case which is under the name of Hiramat. Hiramat के नाम से is जानता है, and it relied upon the 65B proceeding. It talks about curable and non-curable defects. दो तरह के defects के बारे में बात होती है. The defect which can be cured, the defect which are procedural. जिन defect cure कर सकते हो, court will give you a chance to cure that defect और फिर electronic evidence को दोबारा से पेश करा जाए. If the defect cannot be curable, then it's one of the Hiramat is curable and procedural defect.
Excuse me, sir, your voice is breaking, sir.
Okay, so this is a case curable and procedural defects को define करा गया, the landmark case of Hiramat. The next slide. T. Nasir case 23, that is a recent judgment. Production of electronic evidence certificate के ऊपर इसमें later discussion हुआ. If we are admitting an electronic evidence, the court from 2023 says that we also have to a requirement of electronic evidence certificate. उस certificate को भी हमें procedural rules के साथ पेश करना होगा, so that we cannot challenge the credibility and authenticity of the electronic evidence. जो भी कोर्ट में एविडेंस पेश करा जाएगा उसका प्रिस्क्राइब मैनर में और उसकी एक सर्टिफिकेशन फॉर्म में सबमिट करा जाएगा. देयर जस्ट अ प्रिस्क्राइब फॉर्म जो कोर्ट में एडमिसिबल डॉक्यूमेंट्स कराया जाता है. दैट इज बाय दिस जजमेंट टी नसीर 2023. The next one. Key takeaways, I'll just give you a brief. Key takeaways from this slide से क्या है, that we talked about the table, how and what makes or breaks your cybercrime case. We talked about the digital evidence. We talked about the reason, primary evidence, digital evidence primary form, secondary digital evidence. We talk about the legal framework. We talk about the stages, the evolution of the electronic record, which is about pre-2000, inclusive of IT Act 2000, and after 2002 amendment. Then we comes to the legal framework, जिसमें we talk about 65A, 65B certificate prescription. Then we talked about section 63 of BSA 23, and we talked about one of the most greatest and dangerous misconception, that a digital document is admitted into evidence but automatically accepted as authentic, which we talked about, which is completely false. Understand the both terms, admissibility, authenticity. Pura digital evidence record in the courtroom is only on these two words, admissibility and authenticity. So a tip to understand this conclusion, admissibility only establish that the record is legally permissible to be evaluated in the court, but not proved. So the contents, the trustworthy, the genuineness of the digital evidence can be challenged, and that is if that वो टेस्ट पास हो गया, then you will call that evidence is admissible, evidence is authentic. In this case, we talk about the email evidence, CCTV footage, bank transactions, social media, and what would the pitfalls. The most key takeaway was the improper chain of custody, seizure and prevention. Preserve कैसे करना है, what would be the best practices to preserve, what would be the evidentiary value if it went to the forensic department, pre-examination of forensic evidence, post-examination of forensic evidence, where you can create controversies, where you can talk about the strict chain of custody. We talked about the logs, we talked about the hash values. Now we talked about these landmark cases, where we talked about Anwar PV and PK Bashir of 2014, Tomso Bruno 2015, and Arjun Pandit Rao came in 2020. So the proper lesson, key takeaway is proper handling of a digital evidence comes up to the conviction, and if there is any lapse or if there is any error, that comes up to acquittal. So the key takeaway is अगर electronic evidence को properly handle करोगे, you will win the case. If there is an error या उसमें कोई भी lapse होता है, the criminal walks away free, and that amounts to acquittal. So this slide, this all the things discussion details matter more than ever. This is the most important line. We will see the practical tips which we are providing you 65B, 65A, and the next slide, please. The conclusion, if I have to conclude the theme and what makes or breaks your cybercrime case is understand digital evidence, understand the point of admissibility, understand the point of authenticity, understand section 65A, 65B, which is also called section 63A, section 63 of BSA. Understand the point, chain of custody, preservation. If the chain of custody and the right manner of preservation, it can make your case. If there is a lapse in chain of custody and preservation, it can kill your case. So make and kill में chain of custody और preservation का ही खेल है. Proper handling win your cases, improper handling lose your cases. And conclude my remark in this one is I'll give you a formula. Law में भी formula होते हैं that can give you the insight of the content. You can write this formula: authenticity plus admissibility plus forensic report gives you the correct electronic evidence. So AAF, authenticity, admissibility, and forensic report make you win your cases in such cases. Emerging trends में what makes or breaks your cybercrime cases. अगर एक लाइन में बताना हो what makes or breaks your cybercrime cases, the answer is proper handling of digital evidence. Remember, one mistake can acquit the guilt, and one proper process can convict the guilt. That is what it is all about. Thank you for your question. Any question?
Sir, your voice is not audible.
Okay. The last line which I say is remember one key takeaway. One mistake can acquit the guilt, and one proper procedure can convict the guilt. I ended my slide on this point. I'm open for question answer. Any question answer in your chat box, or you can unmute yourself. I'll be here to answer it.
Thank you so much, sir, for such an enlightening session. And we are now opening the floor for the questions from the participants. So please drop your questions in the chat. If you wish to speak, raise your hand and we'll call you one by one. We'll take as many as time allows.
Okay, I'll answer one of the question which is dropped in the chat box, which says WhatsApp chats admissible as an evidence in matrimony cases, where the chat shows the conversation between husband and wife, and what is the role of the hash value in this regard. I'll tell you, Mehak, one thing. जितने भी WhatsApp chats हैं in matrimony case, they are admissible. Now they are admissible. Now you talk about authenticity. Authenticity में आपको section 65B में उसका source बताना पड़ेगा, उसकी journey बतानी पड़ेगी, that how you get the hold of such important evidence. अगर आप ये बताते हैं कि WhatsApp messages and the source is from the account of your client, then it is authentic and admissible. When you say that it is from another source which is not a reliable source, then it is admissible but not authentic. Any exceptions to certified 60B? No, there is no exceptions. Make sure you include all the details, source, content, और कहाँ से वो information ली गई. 65 certificate में सिर्फ इतनी से ही बात बतानी होती. To understand this point, I believe I've answered to your questions. Any more answer?
Yeah.
Any more questions? Okay, the another question is, tell me the example of digital evidence which is collected by unauthorized use. Simple है, अगर आप किसी की ID clone कर लेते हो, or you can also hack someone's account, or let's say you also copy the data from the pen drive CD without the consent, or what you can do, किसी की मोबाइल फोन एक्सेस से आप उस डेटा को किसी और डिवाइस में स्टोर कर लेते हो. All these are the examples of unauthorized access of the digital evidence. Okay. Also, yes, I'll request the host and to please share this PPT with the guest. Is there any way you can share the PPT? I request if you can share, it would be very helpful for them as well.
We will share it, sir. After the session, we will share it.
Okay. And how important is to maintain the chain of custody for digital evidence? What are the consequences if it is not properly documented? The chain of custody talks about only 3 stages. The first stage is the source. The source is the primary evidence, and second is the admissibility, on what ground that you are admitting that document. The third one is before and after forensic evidence. These are the only 3 stages. There can be only one consequence, that your chain of custody, if there is a lack or a error in your chain of custody, it will not consider as credible, but it will be considered only admitted in court. Credibility is the question which can be raised in this case. Any more questions?
Hi, sir. Ananta this side. Yeah.
Hello.
Hi, sir. Am I audible?
Yes.
Yeah. Hi, sir. Ananta this side. So my question is that in today's world, like with the evolving tech, right, and the law that have been, like in terms of how you were saying IT Act, which came in 2000, and various laws that are pre 2000 and post 2000, but still with the evolving tech, we can say in terms of hash value, like we were discussing. These are presented as a gold standard in US, like you were discussing. But with sir AI-based deepfakes and metadata spoofing tools and like these tools are advancing very rapidly, right? So, do you think that our current forensic and legal standard for authenticity are already, becoming outdated, or are they is it outdated or not? Because now the technology is vastly spreading, and like some of the things that we see, it's just like the genuineness are very difficult to be, found.
Perfect. A very good question you have asked, and no doubt, मैं इसमें हिचकिचाऊंगा नहीं, that our forensic labs evidence collection systems are very outdated. which there's the solution to it, setup of modern digital forensic labs, which we call it CFTT or DFSS. European world's countries में CFTT forensic labs preserve data करती हैं, and in the outside of the Asian countries DFSS. So if we set up new modern forensic labs, it will change the scenario of electronic evidence admissibility. We are outdated, but I'll assure you in the next 1 year, you will see that India is setting upon this framework where we are seeing in the IT Act, most modern forensic lab will be set up, and there will be a proper standard which the Honorable Supreme Court is making guidelines also, how forensic evidence or how electronic evidence will be preserved and what will be the proper documentation. I'll tell you, the Honorable Supreme Court have already set up a rough guidelines to preserve the data, and there will be only one documentation for all the cases. अगर एक बार डिस्ट्रिक्ट कोर्ट में किसी भी एविडेंस को रिलेटेड डॉक्यूमेंटेशन हो गई, then the High Court Supreme Court will not required again to access the same documentation with another paperwork. One paperwork with the modern setup of forensic labs will solve all the problem, at least 90% of the problem, which I am hopeful will be concluded in next 1 year.
Thank you so much, sir.
Okay,
That was really helpful.
that was a great question.
Thank you, sir.
Any more questions?
Yes, sir. With this enlightening cyber Sunday session, we now come to the end of our program. We sincerely hope that today's session provided highly informative, enriching, and thought-provoking for everyone present. On behalf of Naksh Foundation and Project Cyber Shield, we extend the deepest gratitude to Advocate Akshay Bamri sir for conducting such an insightful session today. Your profound expertise, lucid guidance, and practical legal perspectives have greatly enhanced our understanding of digital vulnerabilities, forensic compliance, and the legal framework surrounding digital evidence. Before we conclude, we invite you to join the Volunteer for Your Community campaign 2026 by Project Cyber Shield to become a change maker and conduct cyber awareness sessions in your community. Register, simply scan the QR code on your screen. We kindly request all the participants to complete the post-assessment form by scanning the QR code displayed on your screen. Please note that certificates will be issued only upon successful submission of the feedback form. If there is any query regarding the session or certificate, you can mail it event@naksh.org. Thank you for being a part of this learning journey. We look forward